Hey everyone, it's Attorney Kevin back with another video, and I have been getting a ton of questions on the recent DDE reaction video I did in regards to the Lamborghini getting hit by the sledgehammer. So I wanted to make a part 2 and answer one of the main questions that I've been getting as far as holding the employer liable through vicarious liability, also known as respondeat superior. In this video, I'm going to be using Florida law. I'm going to go over a little bit of case law to get started to kind of explain the position. Obviously, there's a couple ground rules as usual. Number 1, this is only my opinion. Obviously, I would need to know more information. Number 2 is each case varies on a case-by-case basis. Like I said prior, details matter, and I would have to look into the case much more deeply before I could form a full legal opinion. And number 3 is this does not form any type of attorney-client relationship. Again, this is merely my opinion going on the limited amount of information I have from the video and then some brief research that I've done. So the first thing I want to talk about is vicarious liability. So basically that means that the employer is in the shoes of the employee, meaning that if the employee does something wrong, then in Florida, you could also hold the employer liable. The video, if you haven't seen it yet, I'm going to put the link down in bio, but long story short, DDE driver is operating a Lamborghini. I guess there were some issues with the neighbors. He pulled over, walks over, talks to the neighbors, comes back and finds that his vehicle windshield has been hit. Walks over and talks to 2 gentlemen that are working nearby, and that's where we are. So a lot of people have asked, again, why are you not holding the employer liable? Well, I've said in the comments before, and I want to talk about Vallejo v. East Coast Furniture Co. That's going to be a 4th District Court of Appeals case in the state of Florida. Quoting from this case, the vicarious liability claim, however, is another matter. On that claim, the issue is not whether the incident was reasonably foreseeable, and I don't think we're really worried about foreseeability here in this issue, but the issue is whether the employee committed the alleged negligent act, 1, within the scope of employment, or 2, during the course of employment and to further a purpose or interest of the employer. So in my opinion, I'm going to say that the argument as far as vicarious liability falls apart because I don't believe that the individual hit the vehicle with the sledgehammer to further the employer's business interest. I don't believe that an employer would tell somebody to hit a Lamborghini with a sledgehammer. Here's a side argument to this, and we would have to obviously know a lot more details if there are negligent hiring issues. So the concept of negligent hiring goes back to 1954. So I'm going to be quoting a case, Mallory v. O'Neill, and that's going to be a Florida Supreme Court case from 1954. And basically the concept of negligent hiring is grounded on negligence of the defendant in knowingly keeping a dangerous servant on the premises which defendant knew or should have known was dangerous and incompetent and liable to do harm to others. Meaning that this individual had a track record of doing something like this in the past, that they didn't properly vet them, interview them, run a proper background check. That, I think, could be a potentially stronger argument than the vicarious liability argument. Like I said, I think it's going to fall apart when you're talking about furthering the employer's business interest. But the negligent hiring argument could hold some fruit. Again, you're going to have to go through a process known as discovery. You're going to have to request a lot of documents. You're going to have to probably do some type of deposition with the employer and with the employee. There's a lot of work that's going to go into that. Essentially, the argument has to be made that the employee was acting in the scope and course of their employment. And I really don't believe that hitting a Lamborghini with a sledgehammer would fall under that. Not to be a smart aleck by any means, but I just don't think it's going to happen. So again, we have to go back to the negligent hiring argument. And as I said, there needs to be a lot more discovery. As always, if you guys have any questions, I'm more than happy to answer them. Thank you so much for watching. I appreciate you all, and we'll see you soon.